Hello, and my name is Jay Berman, and my channel is called The Entrepreneurial Mindset. And today's presentation is Essential Business Law Concepts, Episode 2. The concepts in this video come from my book, The Manual of Essential Business Concepts, which is available on Amazon.com, either as a Kindle, paperback, or hard copy version. To purchase the book, go to Amazon search bar, select books, type in my name, Jay Berman, scroll to my book to purchase, and by doing so, you support my channel and my work in entrepreneurship and business education. Thank you. So today's business law concepts, I will discuss torts and negligence, duty of care, which is the responsibility that businesses have towards their customers, and product liability. So tort comes from the French word meaning wrongs. A tort is, or torts are acts that cause actual physical injury, acts that threaten the personal safety, property, privacy, or reputation of another person. These tort or negligence lawsuits are civil lawsuits, so they take place in civil courts, which I discuss in episode 1. Plaintiffs sue for damages, usually meaning money. So the first thing that incurs in a lawsuit, the plaintiff is seeking compensatory damages, which means these damages cover pain and suffering, loss of reputation, loss of identity, and loss of mental or physical capacity. Special damages are quantifiable monetary losses such as medical bills, loss of income, loss of irreplaceable items, and damage to property. And then the second type of damage is called punitive damages, and this is when the jury grants more money to the plaintiff, and it's usually granted when the injury is particularly terrible or reprehensible. So a negligent tort are torts that cause harm by carelessness, but not necessarily by harmful intentions, which fall under criminal statutes, under criminal law. So these are the types of negligence. The first one is negligent failure to warn that the company knew or should have known that the goods or service would be dangerous in ordinary use or in the foreseeable future. Negligent design, in other words, the product was defective due to the product's design. And negligence per se, the failure to meet minimum legal standards for the production of the good. Then there's a legal concept called respondit superior, which originated in the 17th century, and basically means that the master is responsible for the actions of his servant. But in modern times, it means the employee is under the employer's supervision regarding the time, place, and method of work. The employer is responsible for the actions of his or her employees. The employer can be sued under tort law if any harm or injury to a personal property has been committed by the employee. Then we have duty of care. In other words, what is the company's responsibility towards its customers? The company is responsible for designing, assembling, and testing a product. The company is responsible for selecting the materials to be incorporated into that product. The company is responsible for inspecting and testing materials to be used in the final product, and that the company is responsible for warning labels to inform users of any dangers that the customers may not know. So basically, to sum up, the duty of care is that the company is responsible for the manufacturing of its own products. They design the product, they select the materials, they have to inspect the products and make sure that the final product is safe for customers to use. So the definition of product liability is that customers must be protected from unsafe products, and manufacturers must incur the costs of injuries caused by their own products. Um, and Companies are responsible for the defects of their products. So there could be manufacturing defects. All possible care must be taken to ensure the product's safe design, but defects occur despite quality control. There could be a design defect. A safer design should have been considered, and inadequate warnings. In other words, the company fails to notify users of the potential risk of injury to either the person or to the person's property. However, companies can defend themselves in civil suits. These are some of the product liability defenses. There is an assumption of risk that the plaintiff, the person suing the company, knew of the defects and risks using the product anyway. Product misuse, in other words, the plaintiff, in other words, the person suing the company, used the product for which it was not designed for. And also comparative negligence, which means the plaintiff bears fault as evidenced by his or her action that caused the negligent injury to himself or herself, or to her property or his property. Couple more product liability defenses. Knowledgeable user, if the plaintiff is a knowledgeable user, like an expert, failure to warn of every risk is not sufficient evidence for a lawsuit. The company may not know of every risk for using the product. And of course, there is the statute of limitations. Lawsuits must occur within a specified period of time once the injured party becomes aware of the injury, harm, or damage. So what are the elements of a negligence claim? The defendant owed a duty of care, which again is the duty to not to cause harm to the plaintiff. That the defendant breached his duty of care, that the defendant's breach of duty of care caused the injury to the plaintiff's person or property, that the defendant's action did in fact cause the injury in question. And again, these negligence suits take place in civil courts. I recommend you review my episode 1 on business law concepts. And that's all I have for today. Any questions or comments, please use the comments section below. Just subscribe to my channel for more educational content in entrepreneurship. And thank you for watching.